Marie Beaupre-Olsen. She is the Clare's Law Partnership Coordinator at SAGES, a provincial organization that empowers organizations, individuals, and communities to disrupt structures of domestic violence. Marie completed her Bachelor of Social Work degree at the University of Calgary. She's interested in how prevention efforts be woven within intervention for the systemic issues of domestic violence and sexual violence, and is dedicated to ending these issues in Alberta through her work with SAGES. Okay, we also have Sarah Drohan. She's from the government. She previously worked in victim services in the Ministry of Justice and Solicitor General, but has now been the Clare's Law Coordinator since the program went live in April. And I think in the chat box, we also have another person who is joining us from the government, Loreen Blukey. And so with that, I would like to turn it over to Marie.
Amazing. Thanks, Jane. I will just pop up the PowerPoint here and we can get started. Sorry, just taking a moment to load there. Can somebody give me a thumbs up if you see that PowerPoint there? Amazing. Yeah. Great. Awesome. So as Jane mentioned, my name is Marie Beaupre-Olsen. I am the partnership coordinator for Clare's Law at SAGES. And we're responsible for building kind of the wraparound supports and services for Clare's Law that we'll be talking about later in the presentation. I want to apologize to all of you for my raspy voice. I am a little bit sick today, so thank you for your patience with this as I get through some of the content of the training. But myself and Sarah are really excited that you've all joined us today for the Clare's Law training and are looking to learn more about this initiative. So before getting into the content itself, I do want to offer another land acknowledgement. So as we all gather together from across the province, SAGES would like to acknowledge that we are all on the traditional territories in Alberta of the many First Nations, Métis, and Inuit, whose footsteps have marked these lands for centuries. We acknowledge all First Nations, Métis, and Inuit across Turtle Island as the keepers of these lands, in that many come to live, work, and volunteer in Alberta, enriching our communities. So during the training today and the time that we have together, we will talk about why Clare's Law, the origins and jurisdictions of the legislation, who Clare's Law is for, and some of the eligibility requirements for application, the implementation and role of police, and then finally the social service provider response, and more in depth about those wraparound supports and services that we are currently building with at SAGES. So you'll receive an overview of the legislation, learn about the impacts of Clare's Law on social service providers. We're hoping to build your capacity to support client needs and address their concerns as they're coming forward with Clare's Law questions. And then finally, that you'll be able to identify the roles of police and social service providers or social workers as it relates to the Clare's Law response. So first, before getting really into the in-depth details about Clare's Law, for those of you who are not aware of SAGES and some of the work that we're doing across the entire province of Alberta, we're an organization that empowers individuals, organizations, and communities to disrupt structures of domestic violence. And we're currently doing that in 4 different areas of work. So we have our direct service team that offers peer support-based groups and programs to people who have or are experiencing domestic violence. We have a capacity building and education team that goes into the community and offers workshops on coercive control and how that plays into abuse dynamics. And then our innovation as well as collective impact pillars were pivotal in terms of Clare's Law. So CEGES backbones 2 collective impact initiatives to end domestic and sexual violence in the province of Alberta. And the relationships with the organizations in those collectives served as the starting point of actually building that wraparound supports and services and referral network that we are currently been contracted to build by the government. And then our innovation pillar is actually where Clare's Law stems out of. So a number of years ago, our Director of Innovation and Programming, as well as our CEO, had the opportunity to travel to the United Kingdom. And while they were in the United Kingdom, they were speaking with key stakeholders in the domestic violence sector, and in particular, people who had promoted and implemented efforts that were both intervention, but also prevention led. And they fell upon Clare's Law. And after speaking with some of the people who were involved in the early implementation of Clare's Law, they realized that this was something that was really important to have. It was an additional early intervention tool that would be beneficial for people across the province. And then they decided to start advocating to the government of Alberta for the importance of this law, and then finally led to the implementation of it. So Clare's Law is a Government of Alberta program, and the Government of Alberta is responsible for the day-to-day operations of Clare's Law and all of the ins and outs of disclosing that information to people who are potentially at risk. CEGES has specifically been contracted by the Government of Alberta to serve as the central organization that is receiving Clare's Law referrals when somebody is opted in to supports and services on their application, to undertake the systems navigation that those people would otherwise have to go through if they're looking for supports. And we're connecting those applicants to the appropriate service across the province based off of their needs and their geographical location. So Clare's Law is an extra intervention tool in domestic violence. Now, obviously, it's not the be-all and end-all, but it is an important extra intervention tool at the disposal of people who believe that they're potentially at risk of violence or very much already have experienced that violence, and a starting point into other intervention efforts that could come down the line. So the idea with Clare's Law is that people would have all of the information of the level of risk in their relationship and can utilize that to make fully informed choices about their relationship. So they can utilize what's disclosed to them to empower themselves to make decisions about their safety, make decisions about their relationship, really having the full picture and information that they otherwise might not have had access to. Something else that's really interesting about Clare's Law is that it provides multiple points of entry into relevant supports and services. So even if somebody on their initial application has said no, that they don't want supports, throughout the entire process, they will be asked again if they would like to opt in, and then can retroactively at a later point be connected to that relevant help that can support them with the information they found out during disclosure, the waiting process, or anything that they would like to discuss as they're moving forward after making a Clare's Law application. So as I was mentioning, the referral network is taking out the systems navigation that people would otherwise have to go through. And we're hearing from our partners where we've already referred people to that a lot of those clients that are now accessing services said that they otherwise would have never reached out for supports and services. So it's really interesting and great to see so early on that some of those clients are actually expressing that without this referral process, they otherwise wouldn't have gotten the help that they are now connected to in the province. So Clare's Law is named after somebody. In 2009, Clare Wood in the United Kingdom unfortunately died at the hands of an abusive partner. And in her relationship, Clare Wood had some concerns that there might be some dynamics that were unsafe and that her partner maybe had a history of violence. But unfortunately, at that time, there was no mechanism in place for her to confirm whether or not she was feeling was accurate. And in this case, it escalated to domestic homicide. And a lot of the early advocacy for Clare's Law and the importance of having this as something that people can access was done by Michael Brown, Clare Wood's father, who felt that had his daughter had all of the access to her partner's past history of violence and the risk that she was in based off of that relationship, that things ultimately would have been very different in this situation and wouldn't have ended the way that they did. After this campaigning, in 2014, the United Kingdom and Wales launched the Domestic Violence Disclosure Scheme, which is also more commonly known as Clare's Law in the UK. In terms of other global jurisdictions, Scotland launched this in 2016, Northern Ireland in 2018, and there are multiple Australian state governments that also have this in place. And in terms of global jurisdictions, the way that Clare's Law is implemented varies from jurisdiction. It's not always done through legislation as it was introduced in Alberta. And they all have varying degrees of involvement by police services as well as social services. But what all of the global jurisdictions have similar to here in Alberta is that Clare's Law involves the provision of past history of violence of an intimate partner when the other person in that relationship is concerned or fearful that they might be at risk of experiencing violence. So Saskatchewan was actually the first province to introduce this type of mechanism. In June of 2020, they launched the Saskatchewan's Interpersonal Violence Disclosure Protocol, which works a little bit differently than us in Alberta. In Saskatchewan, people need to go in person to a police station to apply, whereas ours is done online. And they do not have the referral network that we're currently working on building in Alberta. So there's connections to supports and services. In terms of other provinces, Manitoba, as well as Newfoundland and Labrador, have pledged to introduce this type of legislation in the coming years. And there have been multiple Canadian provinces that have indicated an interest in learning about Alberta's Clare's Law model and our wraparound supports and services to see if it's successful in making a difference in the lives of people impacted by violence and in fact, kind of preventing some of that escalation of violence to eventually bring that into their own jurisdictions if it's seen to be something that would be beneficial to implement in their own province. I will pass it on to Sarah to talk a little bit more about the framework.
Hi, everyone. I'm Sarah, as was said before, with Government of Alberta. I'm the Clare's Law Coordinator through Justice and Solicitor General. And so the legislation that we have, it provides this framework for disclosure of information to a person who is at risk or potentially at risk of DV, domestic violence, interpartner violence, and it regards their current or former intimate partner's history of violence. But beyond that, it also allows third parties, as long as they have consent, to apply on behalf of someone else. Now, this can be a victim serving organization, it can be a legal guardian, but we also have a right to know process that we'll get into further, where police can also, under specific conditions, ask for information and proactively relay that to potential victims. And we will get into more details on how all these processes work in a bit. So the Clare's Law, it is under the Ministry of Community and Social Services. It's a CSS-led initiative, But because Clare's law is primarily a justice system process when operational, and because the Ministry of Justice and Solicitor General co-led the development of the law, we are the ones who are responsible for its day-to-day operations. And now Clare's Law has been up and running for just under 5 months since April 1st. And in that time, we've seen over 220 applications thus far.
All right, I can take it back for a few slides to talk about who Clare's Law is for. So Clare's Law is for anybody who has very much already experienced domestic violence or believes that they are at risk of experiencing domestic violence based off of some concerns or fears that they're ongoingly starting to feel in their relationship. And something that's important to note in terms of domestic violence here is that the government and Sarah will be using the Department of Justice's legal definition of domestic violence when reviewing eligibility for Clare's Law. And this legal definition includes the actual or threatened use of force. It has to be within an intimate partner relationship. So there are many definitions of domestic violence in the community, many of which include larger family relationships. For the utility of Clare's Law, it does have to be within an intimate partner relationship, regardless of sex or gender. And it can be a single act of violence or a number of acts forming a pattern of abuse. And some of these patterns of abuse that are under the legal definition of domestic violence include physical abuse, sexual abuse, criminal harassment and stalking, threats to harm children, other family members or pets, property damage, exerting control over movements, communications, or finances, and emotional or psychological abuse. So something that's important to note here is by no means is the government and Sarah going to be looking for evidence that these things have happened. So they're not asking for photos of communication to prove this or photos of bruises or anything like that. On the application itself, there's a text box where somebody has the chance to articulate what's going on, why they're applying the Clare's Law, and that's utilized to determine this eligibility and what people are experiencing. I'll let Sarah talk a little bit more about that later on or now if she would like. But just so that people are aware that people aren't going to be interrogated by any means about their experiences when determining eligibility and these categories.
Yeah, I'll jump in for a second. Thanks, Marie. And by no means, like Marie said, would any claims be interrogated by myself. All of these applications do come in to me to determine eligibility based on the legislation. And one of the bars that need to be met to be eligible, there needs to be some concern for your safety and well-being. And there's a whole gradient of levels of concern that you can choose on your application, all the way from no concern to very concerned. So the first threshold that needs to be met is there is some concern. And so even if you say a little concern, you've already met that threshold. And then, like Marie said, there's a text box provided where you're able to articulate why you are concerned, the person of disclosure, and we'll get into who that is, but essentially the person that you're applying for information on. There's a chance for you to articulate why you are concerned that they will harm you. And this can be so many things. It does not need to raise to the level of you have already experienced domestic violence, because ideally, Clare's Law is able to be a preventative tool. Ideally, you will not have already experienced domestic violence, but we have seen that many applicants have. But in that box, we've seen things such as I've been seeing some red flags. I previously had an abusive partner, and I'm starting to see some of those first behaviors, or someone reached out to me and said that this person was abusive in a previous relationship. There's so many things that can be considered, definitely that don't all rise to have already experiencing domestic violence.
Awesome. So something that we always want to touch on when talking about domestic violence at CEGES is coercive control. It's basically a larger picture definition or look at domestic violence. And it's any pattern of behavior whatsoever that's utilized in the context of a relationship to dominate another person's daily life, to cause intimidation, fear, or control. So when we take that kind of bigger picture look at domestic violence, it becomes evident that these patterns can look like a lot of different forms of abuse that were listed in that legal definition, but really can look like any behavior whatsoever, as long as it's really causing that ultimate fear for the other person. So when we look at that, it becomes even more nuanced, even more highly individualized. And each and every single application for Clare's Law is determined on an individual basis. And even for those who might not be determined eligible, but are experiencing this coercive control, every single person who's applying to Clare's Law is given the opportunity to connect with supports and services, although most applicants have actually been eligible thus far. And some of the really great work that came out of Clare's Law in the United Kingdom and some larger systemic changes that led to Clare's Law's existence is actually it paved the way through the data that came out of Clare's Law to add coercive control into their legal definitions of domestic violence and eventually into their criminal code. Again, because it really painted a picture of what people were in fact experiencing in terms of violence and abuse in the community, and provided the importance of this actually being added into those legal definitions. So it's really great to see how in other jurisdictions, Clare's Law has even led to some pretty big systemic changes overall. Now I'll pass it back on to Sarah to talk more about eligibility.
So anyone can apply to Clare's Law. Of course, that doesn't mean everyone will be eligible. The one caveat for who can apply is obviously you need to have access to the online application. It is mobile friendly, so it can be through a phone or a computer. And like Marie touched on before, one of the main differences between Alberta's Clare's Law and Saskatchewan's is that in Saskatchewan, you have to go in person into a police station to complete that application. And we're hoping to take down quite a few barriers by having it online. And we have seen that in the large uptake of applications since we went live. Now, a main indicator of eligibility is that the applicant resides in Alberta. Now, we wanted to make sure, though, that we want to exclude as few as possible. So you do not need to be a formal permanent resident of Alberta. You just need to be living here at the time of the application. So we want to be inclusive of any immigrant or transient populations to make sure as many people as possible can access the application. And now, why you need to reside in Alberta is that when it comes to receiving disclosure, the police services and RCMP in Alberta are the ones who will be giving that. And so you will need to be residing in Alberta at that time. You can apply on behalf of yourself. And like I said before, you can also be a third-party applicant. So say if you are from a victim serving org, you can apply on behalf of someone else if you've given consent or if they have given you consent to do so. And then also if you have the legal authority of an individual, you can also do that. And we've had a few, parents apply on behalf of their minor children. It would be a situation that we'd most likely see. There's a few more criteria for eligibility. Of course, you need to be in an intimate partner relationship with the person you are applying for information on. And so you either are currently in one or previously have been. And so how we are defining an intimate partner relationship is a relationship between two people, regardless of gender, which can be reasonably characterized as being physically or emotionally intimate or both. And then, as I said before, you need to be able to articulate your reason for concern, your reason for making that application, and then have some level of concern. And when you do apply as a third party on behalf of someone else, you need their consent, and that consent is checked by myself. If you're applying as a third party, I will then reach out to you, the third party, and then the person you are applying on behalf of to confirm that they are aware this application has been made on their behalf and that they do give consent. And while we try to have this open to as many people as possible, of course, things that will make you ineligible. A person cannot use this information to inform others of potential risk. Disclosure is highly confidential. You cannot use this information for any other purpose than making an informed decision about your safety and relationships. So for example, this information can't be used in any court or legal processes and cannot be shared with others, recorded or written down. Disclosure is always given verbally by police officers. We can go to the next slide now to talk about persons at risk. So the person at risk is the individual who's in an intimate partner relationship or was determined to be eligible for disclosure under Clare's law. So a person at risk, as per the legislation, can be that individual identified by police through the right to know process, which I will touch on that briefly. We have two processes, the right to ask and the right to know. Right to know are only available for police to submit. A person at risk, or PAR, can also be the individual determined to be at risk of domestic violence through the risk assessment process through Clare's law. It can also be the parent of a minor who will then also be included in that disclosure interview, or a substitute decision maker with the proper legal authority. And they again will also be included in that disclosure interview. And so it was really important to define these last two subsets of individuals, the guardians or the parents or substitute decision makers. We needed to define them as persons at risk to ensure that they would have the authority to receive disclosure as per the wording of the legislation. It's a little tricky, but we wanted to make sure they could be defined as such so they can hear this information, because obviously they would be in those situations where it's important for them to then act on that information, since they are stepping in for someone who is either a minor or they have legal authority over. We can go to the next on persons of disclosure. So the POD, or person of disclosure, is the person the applicant has current concerns or fears about. So their information is what is going to be provided at disclosure to the person at risk. And so disclosure is the release of that domestic violence related information that's provided to the person at risk. And this will always be provided by police services. It is not provided by the government. It will be given during a disclosure meeting with police. And we'll get into more details about that in a little bit. So like I said, there's two different Clare's law applications. There's the right to ask, RTA. So people who feel they're at risk can apply to find out if their partner or previous partner has a history of domestic violence and other relevant acts. The right to know, again, only available for police. Police can initiate the disclosure process to proactively provide this info to people that they see are potentially at risk of domestic violence. And so they can offer this to a person they see at risk. However, that person does not need to accept disclosure. They can choose to not engage with the process, and then we shut that case down. So mostly what we have seen are these right to ask, or RTAs, where people are applying on their own behalf or a third party for them to receive this information. We can hop to the next one. So Clare's Law Coordinator, that's obviously myself. And so I am the individual who's coordinating all applications for right to ask, right to know, all the way from the application stage to disclosure. And I am the point of contact for applicants, often for our partners at SAGES, as well as for anyone involved in the police services. And part of my role is also ensuring that supports are engaged when requested. people can request supports on the application itself, and then it is my responsibility to send a referral to SAGES, and they determine the next best steps from there on out. And throughout the process, anytime I have contact with an applicant, if they have not already requested services, services are offered again. And we have seen a lot of success in people accessing services through Clare's Law. We're at about 60% of applicants right now are accessing the services offered. So of course, through disclosure, we are releasing very personal and sensitive information. So the government did need to consult with legal and FOIP specialists and the Office of the Information and Privacy Commissioner of Alberta on this privacy and information sharing. And the personal information is safeguarded throughout the entirety of the process. There are very few eyes that land on this, my own being one set. There is only one other person in government who also has access to this, who he is the director of the group who does the risk assessment for these disclosures. And something important to note about this too is that the person of disclosure, so the individual whose information is being disclosed, are never informed that this process has been initiated and this information is not FOIPable. So you cannot request to find out if someone has filed a Clare's Law application against you. That is completely safeguarded, and that information will never be shared. So the person of disclosure will never be made aware or able to be aware that a Clare's Law application or disclosure has gone through about them. So our application process, obviously the individual will fill out the application or the third party on their behalf. Often we've seen multiple victim serving organizations be assisting someone who either may not have access to a computer at that time or doesn't feel they have access safely to a computer in their home. Or we've had some friends and family members fill out on behalf of someone who just feels too overwhelmed by the process itself and needs that extra assistance. And so the person at risk or third party assisting them will fill out the application online. The application is received by myself, and I ensure that it's filled out completely. And once it is, then it's deemed either eligible or not. And at this stage, I do everything in my power to ensure we have the whole picture, all the information we need. If there is questions where it's sort of sitting in a gray area of eligible or not, I will reach out in whatever way is mentioned as safe to do so on the application to ensure that we understand the reasons for concern or the situation, because we want to ensure that as many people that are eligible are receiving disclosure and going through this process. And so there is quite a bit of contact when needed between myself and applicants. Of course, in their application, they state the safest way to do so. And we try and keep the contact as minimal as possible to ensure everyone's safety. But if there ever is questions, we will reach out rather than just mark something ineligible. And like I said, there is always those opportunities as well on application to indicate if you would like to be connected to domestic violence support services. And then if I am in contact with someone, I will ask them again if they would like that. And we've seen a lot of people when it's offered to them a second time, or once they have heard a little bit more about Clare's Law and what exactly will happen, they've been very receptive to receiving supports. So then we'll deem eligible or not and move on from there. So we've already moved through this first initiation and validation, whether it's right to ask or right to know. From there, it's moved to the risk assessment stage. And so ITRAC, which is part of the government, the Integrated Threat and Risk Assessment, they will then be in charge of going through the risk assessment process. And they will have access to relevant information and records to be able to determine a risk level of a person with domestic violence. They prepare the disclosure package and the information that the police will share to the person at risk. That information then comes back to me. I assign it to the designated police service, and they are responsible to schedule and conduct the disclosure interview. At that disclosure interview, they also will offer supports and services once again, and then that information and completed disclosure forms sent back to me again, make sure everything seems to be in order. If they have requested services, I will send out another referral on their behalf, and then the file is closed. And from then on, the Clare's Law process has ended. So at the risk assessment stage, there are 4 levels of risk that can potentially be assigned. And now it's important to note, especially for the first one, insufficient information. We know, I'm sure everyone here is aware, that domestic violence is incredibly underreported for so many reasons. And so the risk assessment process relies on police records. It stretches all the way from calls to service, complaints, protection orders, all the way to convictions. And so if there aren't reports, there is nothing to base a risk level on. And so in those situations, something may come back as an insufficient information or a low risk level, when in reality it could be moderate or high, but they can only make that risk assessment based on the information they have, which often previous incidents of domestic violence have not been reported or recorded. And so it's important that just because something may, and this is reiterated to people at risk as well when they're receiving this information, that just because something may be insufficient information or low, it does not mean or imply that risk is not present, just that the current available information isn't sufficient to determine a more elevated risk level. And so there'll also be times where there's no responsive information. Again, that doesn't mean that you aren't at risk of domestic violence or that domestic violence has not already occurred. And also within these, there's no time frame that's allocated to the risk. So for example, just because you may be allocated a high risk of domestic violence in relation to this particular person, doesn't mean that that violence is going to happen in the next 2 weeks. This is just a general, you are at an elevated risk of domestic violence with this particular person. So now, when disclosure is given, the method it's delivered is based on the risk level. So for insufficient information or low risk, it's been deemed appropriate to conduct these interviews via the phone, and police will still need to confirm information about a person to confirm their identity, such as the verification word that they provide in their application of their choosing. They'll ask for an identification number. Usually someone will use their license number. And then for moderate or high risk, these are supposed to be conducted in person to ensure the safety of the person at risk. And now, obviously with COVID, things have been different. And so there have been some instances where moderate or high risk need to be conducted over the phone or over a video call. And so every police service has sort of tailored what they need to do based on current restrictions and also comfortability of the applicants. But whenever possible for those moderate or high risk, they want to conduct those in person. And again, this is for the safety of the person at risk and to confirm their identity, of course, as well, because there is quite a bit of sensitive information that will be shared at those disclosure interviews. And it is important to note as well that those meetings do not necessarily need to be held at a police station. So this is particularly important in smaller rural communities where it may raise a lot of red flags or be very noticeable by other people in the community if you're going into the police station to go have a meeting. And so you are able to request to meet with police at a location other than the police station. Of course, it will be up to their discretion. They'll determine what is safest and best, but it is fully allowable to conduct those disclosure interviews at places that are not a police station. And again, they will offer supports at disclosure as well. And for the moderate and high risk disclosure interviews, the police-based victim service units are engaged in the process and can provide immediate support. So they do have that option to engage with the police supports. They also have the option and offer to engage with our Clare's Law supports. They can also do both if they would like as well. So we do have two different communications of risk. There'll be the no history of domestic violence or related violent acts. Again, indicates there's no responsive records or that insufficient information. Does not mean there's not risk, that just based on what we can look at, we can't accurately determine a risk level. Or it will say there's a confirmed history of domestic violence or related violent acts. So that there were records available where that violence was documented in the person of disclosure's past. And so these related violent acts will include threats, criminal harassment, non-domestic violence related violence, stalking, if there have been previous protection orders put on these people from previous relationship. And then again, with this risk level, so either insufficient, low, medium, high, you'll also be given some contextual information with respect to why you were assigned that risk level. So this can speak to severity, frequency, recentness of these acts that contributed to you getting that level assigned. And they try to be as detailed as possible without giving names or dates. However, this information again is completely confidential and it's given to you. It can't be recorded by you in any way. It cannot be written down. It is just given to you verbally by the police officer. The risk assessment team puts the disclosure package together. They write out all of the contextual information, and then the police are tasked to read that verbatim to you so you can get that exact information that the risk assessment team has compiled.
Great. So now I'll go a little bit more into the role of social service providers. So as some of you on the call, and then the SAGES referral network and the ins and outs of how we are referring folks, and hopefully getting some of you on the call added into our Clare's Law referral network if your services would be appropriate. So as Sarah and I have mentioned multiple times, throughout the entire Clare's Law process, people have the opportunity to opt in to supports and services. And basically on the online application, so the first point, when somebody says yes, that they want supports, an additional pop-up comes up where they have the chance to select certain key demographic areas or certain areas of service that they would like. So for example, somebody could indicate to us that they're specifically looking for some 2S LGBTQS plus services in Grand Prairie. Or somebody could say on their application that they are looking for older adult abuse services in Southern Alberta. So there's quite a number of different tags, and then we are using tags that people have indicated on their application and then filtering that through our database. And basically our database will match to the organization's tags and come up with a list of the top 3 to 5 organizations that would be positioned to actually support that person. One of our social workers takes a final review of the Clare's Law applicant's information, some of the contextual pieces as to why they applied to Clare's Law and their tags, the specifics of service that those organizations offer that are in the final list, and then we'll make a determination as to which best and final organization would be positioned to support that person in the province. Once that one organization or service provider has been selected, a referral email will be sent to that organization's Clare's Law primary contact. And in that email, it will include 2 links. One link is to access a redacted version of that Clare's Law applicant's application, basically, their contact info, where you can reach them, as well as a secondary link, which will be to the referral completion form that folks would submit once they have successfully connected with that person to provide us with feedback as to what happened during that interaction. And there's a few different routes that this referral can take. The first would be that an organization reaches out to the person, they successfully connect with that applicant, schedule an intake, and the person basically goes on from there and is a regular client. At that point, the referral agency would fill out the referral completion form indicating a successful referral, and then the referral process would be completed. Another possibility is that the organization reaches out to that individual. Upon connecting with that person, the client has decided that they no longer would like supports and services, so they've declined supports. Similarly, the referral completion form would be submitted indicating a client declined supports, and then the referral process would be completed yet again. Another possibility is that the organization has attempted the 3 contact attempts that we are offering, that we are asking organizations to complete. And after the 10 business day period, we are also providing organizations to complete the Clare's Law referrals, have not heard back from the person that they were referred. At that point, it would be counted as a client has declined services, and then the referral completion form would be submitted, indicating that those 3 contact attempts did occur, but ultimately you were unsuccessful at reaching that person. The final possibility of one of these referrals is that either you receive the referral and notice based off of the person's application that their needs are outside of your scope of practice, or that their needs just do not fall under what you're actually offering. Or you've reached out to that client and that person indicated that they do want supports and services, but just from another organization because they're looking for something else. If this occurs, then the organizations in the referral network would fill out the completion form indicating a re-referral and the reasons for that. And then basically we will utilize that information and the original tags to start the process again to refer that person to another organization that would be positioned to support them in the province. So some of the communication with organizations in our referral network. So I did mention it, but I'll say it again. So we are asking organizations in the network to complete 3 contact attempts with these applicants over a 10 business day period, with that first attempt happening within 2 business days of that referral being received, so that Clare's Law applicants can be connected to supports and services as quickly as possible, but also to allow them time to actually get back to that organization if they don't originally answer the call. If the referral completion form is not submitted within 20 or 48 hours, then the reminder emails will come out of our system at the 48-hour mark, 5 business day mark, and then again at the 8 business day mark. And these are just reminders with the referral completion form to follow up on those 2nd or 3rd contact attempts that still need to occur. If SAGES does not receive a response from that organization within 10 business days, so the referral completion form was never submitted and I have not connected with the primary contact from that organization, then what would happen is that we would actually pull that initial referral and immediately re-refer that person to another organization so that they can receive supports and services. And part of my role as partnership coordinator for our Clare's Law referral network would be to reach out to that organization at that time. see what happened, what barriers got into place that got in the way of them actually connecting with that Clare's Law applicant and completing the referral. And we just work together to mitigate those in the future and making sure that that organization is still positioned to be able to respond to Clare's Law referrals in a timely manner. So as I was mentioning on one of the very first slides, is the beginning point of building this Clare's Law referral network was the relationships with organizations that SAGES has through the Calgary Domestic Violence Collective and Impact, which is the provincial collective to end domestic and sexual violence. We are ongoingly building this referral network with both formal organizations and informal supporters who are offering supports to people touched by violence in the province. So if you are an organization that is not part of the Clare's Law referral network and you would like to be part of the referral network, you can scan this QR code and it'll pull up the survey that we're using to add new organizations to the network. You'll be able to indicate the primary contact for Clare's Law at your organization and some of those tags of service that you would specifically offer. And then your profile will be added to our database. And once our admin and tech team lets me know that your profile is live, I would reach out to schedule a meet and greet and discuss next steps for being part of the network. If you're not sure if your organization would be a good fit, if you're already part of the network, or if you know of organizations outside of where you work that's in your community that we really need to touch base with to be added to the network, I will provide my contact information in the chat box at the end of the presentation, and I would love to connect and talk about this referral network and domestic violence supports and services in your area more, again, because we're really trying to build as robust of a referral network as possible to really make sure that we can respond to the diverse needs of people touched by violence and applying for Clare's Law across the province. So in terms of supporting social service providers and some of the commitment that SAGES is really, we're here to support with you folks. We're here to make sure that there is the effective service provider response to those Clare's Law referrals, that 3 contacts is happening within 10 business days, and at the very best in most cases that first contact is happening within 48 hours. We're ongoingly adding new organizations and service providers into the Clare's Law database. We are here to inform service providers on their roles for referrals and ongoingly supporting organizations who are part of the referral network about the ins and outs of responding to referrals and any of their needs as being part of our network. And we're also here to schedule any consultations with service providers when looking to support clients through the Clare's Law application process, or really anything related to Clare's Law and supports and services. And then in terms of you folks on the call and how you can be a part of Clare's Law beyond receiving referrals and being part of the network. You can inform clients about Clare's Law and letting them know that this is an extra tool if they are expressing concerns of violence or disclosing experiences of domestic violence. You can also assist clients in completing the online application, helping them get their basic information down, or writing out why they're applying to Clare's Law. And then with a person's consent, you are absolutely welcome to apply as a third-party application on behalf of someone who would maybe feel more comfortable with you moving forward with the application on their behalf. This is my email for any of you folks that have questions about the referral network. I'll add this as well as my direct phone number in the chat box once I stop sharing the PowerPoint, so all of you can note this down. And then finally, we are providing this training to a number of service providers across the province and really want to make sure that it is equipping all of you with what you would need to be able to talk about Clare's Law with your clients. So if you have any feedback on how we can improve this presentation or anything that we can change to make sure that the information is adequately dispersed across the province to social service providers, please let us know. Again, you can scan this QR code to a very short survey, but I will also pop the link into the chat box if any of you feel more comfortable submitting an online web version of this survey. So I will stop sharing and we can get into some of the questions.
Just quickly as well, I'll put my email into the chat box too. So if you have any questions that come up later after this for anything to do with Clare's Law, please feel free to reach out to me as well.
So if you have any questions at this point, we'll, if you raise your hand or put it in the chat box, that would be great.
Hi there. I hope you can hear me. This is Amanda. I just have a question for Sarah. I just wanted a little bit more of a clarification when you mentioned if it's a guardian or a parent. Now, is that something that you still need to get permission from the youth or the person that is under guardianship when you do that process?
No, if you are someone's legal authority or parent, guardian, you do not need to have the consent of that person to file the application. It would only be in those situations if you're just a friend, a sister, a victim serving organization. In those cases, that consent needs to be present and will be followed up by myself with the person at risk to confirm that the consent was given.
Great, thanks so much for that.
Teresa?
Yeah, I have a follow-up with that. So that's for only minors. What if you are a parent of an adult child who you have significant concerns? Does that adult child need to provide you consent or need to provide you guys consent to continue the process?
Yes, they will, unless you have guardianship over them for, we've had an application for an individual with a cognitive disability and they're an adult. Their parent has that legal authority over them. And so they do not need to provide consent. However, if that's not the case, that consent still needs to be there. And how it works with disclosure and third parties is the only people that will receive the disclosure information is the person at risk or the person defined as person at risk. So that does include guardians or individuals with legal authority. That does not include third parties who are a victim serving organization. So if you are assisting, your friend, or you are working from your victim serving org and filling that out, you will not be the one who receives the information at the end. It'll just be that person at risk.
Hi, my name is Nazred, and I have a question about the risk assessment level. Who decides what the risk level is, whether it's low, moderate, or high? Is it the person that is applying for Clare's Law, or is it the provider?
So
certain-
the person that decides the risk level is actually a team of risk assessors with various backgrounds in social work, law enforcement, criminology. And so they are the ones who will receive all of the records from police, be able to view everything, and they have a highly systematized process they follow when they review all of that information to then determine what that person's risk level will be. Does that answer your question?
I would like disclosure and transparency in terms of what their system is that they use to assess what low, moderate, and high is.
Absolutely. So that would be a question that one of my coworkers, Alexander Thompson, who's the director of ITRAC, the Integrated Threat and Risk Assessment, that can be something he can speak to. If you want to pop your information into the chat, I can put you two in contact and he can provide you some more details about what exactly that looks like.
Okay, thank you.
Yeah.
If I can just pop into Nazareth, this is, you will want to talk to Alex, but I can tell you that the team of folks through iTrack who do their risk assessments, they are very highly educated, highly trained, and they do assessments based on risk assessment tools and proven methods that are used by law enforcement agencies throughout Canada. And so it is a very rigorous process to become a threat assessor. And you know, this also does threat assessments for police on domestic violence cases. So they are a very highly qualified team of individuals.
Thank you, Laurie. Yeah, my concern is that historically women are just not taken very seriously when they report incidences of violence and concerns for their safety. So, and I think that's one of the reasons there is such a high domestic violence towards women in Canada. And so I'm concerned, you know, in regards to who decides what low, moderate, and high is, because the person is concerned. She's, you know, like, to me, she's the only one that actually can say if it's low, high, or you know, like she shouldn't be disregarded in this process. I mean, she should be included in the, you know, decision as to whether it's low, moderate, and high. And usually they're not included in that decision-making process. And femicide is very high in Canada, and it's a big concern, and it's not taken very seriously either. So yeah, I'm wondering about all these things, about the decision-making processes. Is it just men deciding? Is it just the police? Or, you know, what is the process? I'm not very familiar with, you know, Clare's law, and I'm really, I just, from the bottom of my heart, thank you so much for this educational session, because it's so amazing that you guys are doing that. Thank you so much for that. And I welcome all this information that you can provide to me to understand all this. Thank you.
Yeah, and I agree with everything you're saying. And I think it's really important to reiterate that we're fully aware that just because a risk level may come back with those tools as low or insufficient information does not mean there's not risk. And often what we've had a lot of people being communicated to them through police as well is that you know when you're at risk, and that this is supposed to be a tool also that can help, like Marie said, empower you and give you further information you might not have known before to make that informed decision about your safety and your relationship. And so this is by no means again, like Marie said, the be all end all of domestic violence intervention or tools, but it is just one that is in our toolbox now that will hopefully have some power and influence in these people's lives. But definitely this risk assessment is not the final say in what your risk level is actually in the world.
Thank you.
Pauline?
Hi, yeah, this has been excellent information presentation. Thank you very much. How does it specifically apply to elder abuse? The financial, emotional abuse is most common. Usually it is a family member, but not always, sometimes, like, for example, the romance scams. And quite often threatening pets is happening as well. But how does it relate to elder abuse? Or how can people in the elder abuse field best use Clare's law to help their clients? Maybe a better way to ask.
And Lorraine, feel free to jump in if you have anything to add as well. I think that, of course, Clare's law, the way that it can be used is if that elder abuse is occurring inside an intimate partner relationship, because that is the scope of Clare's law, and that eligibility hurdle, there needs to be the presence of an intimate partner relationship that these concerns are occurring within, whether that's actions that have already occurred, like you said, threats to animals. That is one of the things listed in our coercive control and domestic violence definitions. Whether it's those things have already occurred and you want to understand the risk that you're at, or if you are you're seeing some red flags, some indicators that these things might occur. But again, it needs to be happening within the context of an intimate partner relationship for Clare's law specifically. And as well, I believe Marie touched on this too. Anyone who applies to Clare's law, whether or not you're going to be eligible, you do have the opportunity to request support services, and that referral will be sent out on your behalf, eligible or not. That's the first step that goes through when I receive an application. Before I go through eligibility, I see if they've checked yes or no to requesting supports. And if they said yes, that referral goes out immediately, and then we get into eligibility. So even if someone were not to be eligible, they will have the opportunity to be put in contact with supports if they desire to be.
You know, and I'd just like to add too that this isn't a substitute for calling the police either. I mean, if you're in immediate danger or if you know somebody who's in immediate danger or something is happening to them, you know, that is abusive or something, they can certainly make a Clare's law application, of course. But the thing is, if they need to be calling the police or going to a shelter or something like that too, then you know, you might have to present that option to them so that they can achieve some immediate safety while they're awaiting you know, maybe Clare's law information or something else like that. Because a lot of the local police too, like they have their own elder abuse task forces and things like that too. You know, and you wouldn't be waiting then, you know, I think for safety guidance, you know, as you're waiting for Clare's law information. So I think you can, you know, do both then.
Thank you very much for your comments. So is there any other questions that we have? No. So it's a very interesting topic, and I think we have to go through it several times to really get the feel of it and see what we have in our own communities that will support this.
Awesome. Doesn't look like there's any more questions. So just a reminder that we will be sending out an email with a short survey link. I will also leave it in the chat box below, on the side. And yeah, as I also put in the chat box, we welcome any of you who haven't made a core account with us on Core Alberta to make an account and then join the elder abuse group, as there are more exciting learning opportunities in the future. And also it's a nice space to share resources with one another. And yeah, thank you so much for our presenters today. We wish you all a very great day.
Thanks everyone for your time. Like I said, feel free to reach